Hello everyone, welcome back to the video on explanations to the principle of res judicata. Here, this is another second video on the res judicata. The first video that I made was talking about the res judicata main body, and this video will be talking about the constructive res judicata and all the explanations related to it. So please watch the first video. If that is clear, then you move on to the next video on explanations and the concept of constructive res judicata. So the explanation one of this particular concept of res judicata talk about former suit, the meaning of former suit and the meaning of a subsequent suit. And it says that the former suit is a suit which is decided prior to the suit in question. Matlab, we do not go into the question of the date of institution of the suit, but we check the date of decision of the suit. So that I covered in the last video as well, but I'm repeating it again here. Explanation 2 talk about the competency of the court, that also we discussed in the last class or in the last video, which says that competency of the court is not determined on the basis whether the decision can be appealed or not. A decision, even if can be appealed, will be considered as heard and finally decided. Along with that, we will say that the court which is decided is a competent court, even if later on you can go for an appeal. So competency will not be decided whether the case can be go for an appeal or not. Irrespective of that, if the court has territorial, pecuniary and subject matter jurisdiction, the case will be considered as has been decided by a competent court. Explanation 3 says that whenever we talk about the matter in question, that the matter is directly and substantially an issue or not, for that we will see whether the matter is raised by one party and accepted or denied by the other party. So the party must either accept or deny that particular matter, either expressly or impliedly. For example, there is a case wherein the person has said that uh, person has talked about 1, 2, 3, and 4 facts, and the other party has accepted 1 and 3 point and has rejected 2 and 4 point. Then in those cases, these are the accepted matter, these are the denied matters, but all these matters are the matter in issue. But if something, there is a fifth point which is not stated or accepted or denied by the other party, then it is not a matter which is in controversy, and therefore we will not call that matter as directly and substantially in issue. Again, for this particular point, there is a concept related to the matter which is a matter collaterally and incidentally in issue, that is given or explained in the previous video on res judicata. You can refer to that to understand which can be this particular fifth matter which is not directly and substantially in issue but collaterally and incidentally in issue. Coming to explanation 4, it talks about a matter which might and ought to have been made ground of defense or attack in former suit shall be deemed to have a matter directly and substantially an issue in such suit. In this particular case, a legal fiction is created by using the term deemed. So it includes a matter which has not been included in a former and a subsequent suit but should have been raised in a former or subsequent suit and will be considered as has been raised. तो पहले तो यहाँ पे क्योंकि deemed है तो that means a fiction is created, and that is why we also consider the matter which fall under explanation 4 as constructive res judicata, because by construction, by legal fiction, we include it in res judicata. So the example of it is that if a matter has not been raised in a previous suit, for example, there was a suit between A and B related to a particular point on ownership over a property, ownership and possession. Here the grounds raised by A in the first suit was that he is the owner on the point of a will, that there is a will which makes him the owner of a property. Later on, another suit was filed. So this particular suit, in this suit, will was rejected, and the court said that will is not registered, and it is not in favor of A and not a valid document, and therefore A is not the owner of the property. In the subsequent suit, A said that there is a sale deed as well in my name, and therefore on the basis of the sale deed, I am the owner of the property. Now this ground which A raised in the subsequent suit is not exactly same with the former suit. It is different. However, it is based, or it is on the same relief that this person is claiming, A is claiming. So the concept mentioned under explanation 4 says that all the ground of attack or defense that you have raised in a subsequent suit or that you ought or should have raised in a former suit should be same. यहाँ पे ओनरशिप जब वो क्लेम कर रहा है तो चाहे फिर वो विल के बेसिस पे हो, चाहे वो सेल डीड के बेसिस पे हो, चाहे वो किसी और डॉक्यूमेंट के बेसिस पे हो, all these grounds should have been raised in one suit only. If he has not raised all these grounds in one suit, then he will be barred from raising it in a subsequent suit because a legal fiction will be created stating that he has already raised. So this particular ground of sale deed might or ought be raised in this former suit. This former suit, we will consider this as a suit 1. We will consider this as suit 1, and the subsequent suit will consider this as a suit 2. So the ground which was raised in suit 2 on the of the sale date might and ought to have been raised in the former suit of suit 1, and if it has not been raised, it will be deemed to have been raised, and therefore the subsequent suit will be barred. तो यहाँ पे रेस नहीं हुआ है लेकिन ये लीगल फिक्शन क्रिएट हुआ है, इसलिए हम इसको बोलेंगे कि ये रेस जुडिकेटा तो नहीं है क्योंकि एक्चुअल में रेज नहीं हुआ है, लेकिन क्योंकि कंस्ट्रक्टिवली रेज हुआ है इसको हम बोलेंगे कंस्ट्रक्टिव रेस जुडिकेटा. So this is the principle of constructive res judicata. Let's give another example that is also the fact of the case Nawab Hussain versus State of UP. In this case, the first suit was filed by Nawab Hussain on the ground that he challenged basically his removal from a government office, claiming that he was not given a right to be heard. Okay, so Nawab Hussain raised an issue in the first case, suit 1, wherein he said that he was removed from an office by violating the principle of natural justice because his right to be heard was violated. Okay, the court said that this particular right was not violated and therefore his removal was valid. He raised subsequent suit, that is suit 2, on the ground. So now the second suit which was raised, it was raised on the ground that the appointing authority was the DIG. The appointing authority was the IG and the removing authority was DIG. Since constitutional principle is there which says that if your appointing authority is higher than is a particular person, the removing authority cannot be a person in the lower grade or lower rank. It can either be the same authority or in higher authority. And he said since the appointing authority was IG, the removing authority can be either IG or a person above the rank of IG, but not anyone below the rank of IG, that is DIG, and therefore the removal was wrong. The court said that although this particular point was not raised, this matter of defense, basically attack in this case, was not raised in the former suit. The point was only related to the violation of the principle of natural justice because he was not given the right to be heard. But in the subsequent case, the court said that the ground or the relief is the same, and therefore this ground could have been raised in the first suit and should and ought to be raised in the first suit, and therefore this suit will be barred by the authority of deemed or the legal fiction that it has been raised in the former suit, and therefore constructively the person will be barred in raising the same plea again. So here the constructive res judicata will be applicable and suit 2 will be barred. So these are some of the examples related to the constructive res judicata. Coming to the next explanation, it says the relief claimed which is not expressly granted will be considered as has been refused. तो अगर किसी person ने दो relief मांगे हैं, for example damages has been claimed and specific performance has been claimed, and the court has given him specific performance but is silent about the damages, then the court will be considered as given one relief and denied the other relief, even if the court has not expressly said anything about it. Explanation 6 says that the parties who have claimed or who has got any kind of interest or derived any interest from one suit, all the party will be barred. So litigating, जब हम बोलते हैं litigating under the same title, it includes all the interested party in that particular suit. जैसे अगर आपने एक सूट फाइल किया जिसके अंदर you are representing the interest of two more people, although those people are not arguing in the court, but if you are representing their interest and they have been benefited out of the decision of the court, then those people cannot file a fresh suit on the same case क्योंकि उनको already benefit मिल चुका है. ठीक है, तो this res judicata is applicable on all the people who have been interested and has got the benefit. Now, explanation 7. Explanation 7 says the res judicata principle will be applicable even in the cases of execution. So, if a decision has been executed once, the same decision, the same decree cannot be executed by some other court if the first court was competent to execute that decree. So, once a decree has been executed, cannot be executed again. That is the principle of res judicata applied on the execution decrees. So, the explanation 7 and explanation 8 were added by 1976 amendment to make more clarity that once that the res judicata will be applicable even in the execution of a decree, and res judicata will be applicable on the concept of a court of limited jurisdiction. For that, again, I will give you an example. Let's suppose there is a court in 2011 which was related to a particular property. This property was of 20 lakh in 2011 and the decision came in 2018. Now another suit was filed in 2020. By that time the price of the property increased to 40 lakh. The decision which was given in this particular case was given by a court of junior division which had the jurisdiction till 20 lakh amount. Still in 2020, this junior division court has the jurisdiction of only 20 lakh amount, but since the price of the property has increased to 40 lakh, the party who is filing the subsequent suit has reached to senior division court who has the jurisdiction till 60 lakh, claiming that the decision given earlier was given by an incompetent court क्योंकि अब junior division court सिर्फ 20 लाख तक का ही मैटर डिसाइड कर सकती है और प्रॉपर्टी अब 40 लाख की हो चुकी है. तो यहाँ पे क्योंकि ये 40 लाख की हो चुकी है, the earlier court became incompetent and therefore this incompetency will not bar the subsequent suit before the senior division court. तो यहाँ पे explanation add हुआ after the decision in Sulochna Amma case came. I'll add the name of these cases in the comment box, which you can see the citation and the detailed name. ये सुप्रीम कोर्ट ने डिसाइड किया था और सुप्रीम कोर्ट ने कहा था कि इन कोर्ट्स को हम कोर्ट ऑफ लिमिटेड जुरिस्डिक्शन बोलते हैं जिनके पास पहले जुरिस्डिक्शन थी बट बाद में वो जुरिस्डिक्शन नहीं रही बिकॉज ऑफ सम रीजन. यहाँ पे जस्ट बिकॉज there is a change, let's say in this particular example there is a change in the economy or basically inflation has resulted into the increase in the price of the property, but the court has not become competent. The court has incompetent. The court has become incompetent because of some external reason, not because the court cannot decide that particular suit. If that is the case, the court which has become now incompetent is a court of limited jurisdiction, and the decision of the court of a limited jurisdiction which was given earlier when they were competent will bar a subsequent suit in which they do not have the jurisdiction. So even if this court does not have the jurisdiction now in 2020, since earlier it had the jurisdiction and competency to decide in 2011 to 2018 when the decision came, the decision in 2020 or the subsequent suit in 2020 will be barred by that particular judgment which was given by that limited court's jurisdiction, irrespective of the fact that this court cannot decide now the subsequent suit. So therefore, even in a court of limited jurisdiction, the application of res judicata will be there irrespective of whether that court can decide the subsequent suit and whether the court has a competency to decide that subsequent suit. So I hope all this is clear. If it is not, you can always come to me, comment on it, and I'll try to explain it again in detail by making another video or solving those doubts in the comment section. Please refer to the cases in the description of the video, and please like and subscribe my video if you like my videos. Thank you. Have a nice day. We'll meet again with the new topic in the next video. Thank you again.